This video is intended to give a brief overview of your legal options. However, nothing contained herein shall be considered legal advice. This video doesn't cover all the issues you might encounter or discuss any particular issue in depth. Before proceeding with any legal decision, the best practice is to review your particular case with a knowledgeable attorney. Nothing in this video creates an attorney-client relationship. What is Chapter 13 bankruptcy? Chapter 13 bankruptcy, also called the wage earner's bankruptcy or reorganization bankruptcy, is one of the two most popular types of consumer bankruptcies. The other one is Chapter 7 bankruptcy. In Chapter 13 bankruptcy, you keep your property and repay some or all of your debts over a 3 to 5 year period. What debts you repay, how much you pay each month during the repayment period, and what happens to your debts at the end of your case, is all laid out in your Chapter 13 repayment plan. Chapter 13 bankruptcy is often a good choice for people who want to keep property that they would otherwise lose in a Chapter 7 bankruptcy. And because you can make up arrearages in your repayment plan, Chapter 13 is often the only bankruptcy choice that will allow you to keep your home if you are facing foreclosure. How is a Chapter 13 bankruptcy plan payment calculated? In Chapter 13 bankruptcy, you propose a repayment plan to pay back some or all of your debts over a 3 to 5 year period. Your payment might be higher, however, because a Chapter 13 plan payment depends on many factors, including secured debts, priority debts, where you live, your income and expenses, whether you own non-exempt property, and the types of debts you have. For instance, you'll have a higher payment if you have a lot of disposable income that could be used to pay other creditors, or if you can't protect all of your property with a bankruptcy exemption, non-exempt property. Chapter 13 filings are complex. Filing without a bankruptcy lawyer isn't recommended. Steps in a Chapter 13 bankruptcy case. Although the procedures in Chapter 13 bankruptcy are somewhat simple, it's important to understand what you are getting into when you file. In a Chapter 13 case, you make payments to the bankruptcy trustee for 3 to 5 years. You must file a lengthy set of official bankruptcy forms, and attend the meeting of creditors, and possibly the confirmation hearing. If you comply with the terms of your confirmed plan, when the case is over, you'll receive a discharge of some debts. Most Chapter 13 filers hire an attorney to help navigate the Chapter 13 process, and most bankruptcy courts strongly advise doing so. Even if you're represented by counsel, it's a good idea to understand what a Chapter 13 case will involve before you embark on the process. Here's what you can expect in a typical Chapter 13 from start to finish. You take and complete a credit counseling course. Within the 6 months before filing for Chapter 13 bankruptcy, you must take a credit counseling course from an agency approved by the U.S. Trustee's Office. The list of approved agencies is on the U.S. Trustee's website. You can also learn about exceptions to this rule. You'll prepare the bankruptcy petition and the proposed Chapter 13 plan. You must complete a large packet of forms consisting of the bankruptcy petition, schedules, and other required forms. In these forms, you'll be disclosing all of your property, debts, income, property transfers, and more. You must also draft and submit a proposed Chapter 13 repayment plan. The repayment plan is the crux of your Chapter 13 case. It's fairly complicated to come up with a plan that meets all legal requirements. This is one reason why many Chapter 13 filers hire an attorney. You file your bankruptcy petition, proposed plan, and other required documents. You or your attorney will file the bankruptcy papers along with your most recent tax return and proof that you filed tax returns in the last 4 years. The court appoints a bankruptcy trustee to administer your case. The trustee is charged with reviewing your plan and ensuring it complies with the law, collecting payments under your plan and distributing them to creditors, and monitoring your monthly income and expense reports, among other things. The automatic stay takes effect. Once you file your papers, the automatic stay goes into effect. The court will notify your creditors of your filing and the stay. The automatic stay prohibits most creditors from continuing with collection actions. A few exceptions to the automatic stay exist, and some creditors might ask the court to remove the stay. You make your first plan payment. Even though your plan will not yet be confirmed, You must begin making payments about 1 month after you file your papers. Attend the Meeting of Creditors. Also called the 341 hearing, the bankruptcy trustee conducts the meeting of creditors in a room other than a courtroom. The trustee will ask you a series of questions about your papers and finances. Creditors can ask questions too, and may object to your proposed plan. Attend the confirmation hearing. You or your attorney must go to one court hearing, called the confirmation hearing. This is where the court will address any plan objections made by either a creditor or the trustee. If all goes well, the court will confirm your plan. Creditors file proof of claim forms so that they can get paid. You can object to a proof of claim. And if an important creditor doesn't file one, you might want to file one for the creditor yourself so that you can pay the debt as part of your case. For the duration of the repayment period, you must make your plan payments, and might have to submit certain documents, like income and expense statements. You must complete a debtor education class before the end of the case. This is separate from the credit counseling required before bankruptcy and discussed in Step 1. If the plan is completed successfully, and the repayment period ends, the court will grant a discharge. The discharge wipes out any remaining balance of qualifying debt. The court might hold a discharge hearing or choose to mail you the notice without holding a hearing. Exemptions in Chapter 13, reducing your payment. Chapter 13 bankruptcy works differently than Chapter 7. In a Chapter 13 case, the debtor proposes a 3 to 5 year repayment plan where the debtor pays back some or all of debts. The Chapter 13 trustee distributes the funds to creditors. Creditors in a Chapter 13 case must receive at least what they would have received if the debtor had filed Chapter 7. So the debtor must pay unsecured creditors an amount equal to the value of the non-exempt assets, those things that would have been sold in a Chapter 7 case. In most instances, the more non-exempt property the debtor has, the higher the Chapter 13 plan payment will be, so exemptions help reduce the amount the debtor must pay into the Chapter 13 plan. Example: if a debtor has $1,550 of non-exempt equity in a car, the debtor must pay enough into the Chapter 13 plan to provide $1,550 to unsecured creditors over the life of the Chapter 13 plan. What can a debtor expect at the bankruptcy meeting of creditors? The Meeting of Creditors, 341 hearing, is an important part of every Chapter 7 and Chapter 13 bankruptcy case. All Chapter 7 and 13 bankruptcy filers must attend a 341 hearing and meet with the trustee appointed to oversee the case. At the creditors meeting, the trustee checks the debtor's identification, and asks a series of questions about the bankruptcy paperwork. Creditors who attend can ask about financial matters, although it's rare for creditors to appear. It's common for debtors to worry about the meeting, but most are quick and proceed without a hitch. Here's what you need to know to handle the meeting with confidence. How to prepare for the meeting. What to bring to the hearing. How to get to the hearing. The type of questions you'll be asked, and what to expect if creditors appear. The next step for Chapter 13 filers is getting the Chapter 13 repayment plan approved at the confirmation hearing. Understanding the trustee's role in the meeting of creditors. The trustee's job is to check your identity, review your paperwork for accuracy, and make sure that your creditors get paid as much as possible. For instance, in every case, the trustee will evaluate assets and property, and check the accuracy of your reported income. The trustee will also try to find any unreported sources of income or property, to pursue to get more money for your creditors. Finally, the trustee will look for signs of bankruptcy fraud. The Chapter 13 trustee will evaluate the feasibility of your proposed Chapter 13 repayment plan. If the judge approves the plan at the confirmation hearing, the Chapter 13 trustee will continue to distribute monthly payments to creditors. Debtors begin making the proposed plan payments about 30 days after filing and receive the funds back if the court doesn't confirm the plan, with some exceptions. Preparing for the meeting of creditors. Before the meeting of creditors, you'll want to review your bankruptcy petition carefully. If you find that you've missed something or see an inaccurate entry, you should file an amendment before the hearing, if possible, or be prepared to bring the problem to the trustee's attention at the hearing. A common issue that can occur is failing to list your name exactly as it appears on your license. passport, or government identification card. You'll provide one of these forms of identification, along with proof of your Social Security card number at the beginning of the hearing. If they don't match, you'll have to amend your petition and will likely have to come back a second time. What to bring to the 341 hearing? In most cases, you'll have provided verifying documents to the trustee before the meeting of creditors. It's common to send the trustee paycheck stubs, bank and retirement statements, and income tax returns. Some trustees require additional documents, and in some courts, you'll file the documents with the court. You shouldn't need to bring much to the hearing other than an approved photo ID, your Social Security card or other proof of your Social Security number, and any documents that reflect a financial change since filing your petition. You'll likely want to bring a set of bankruptcy paperwork to refer to, along with anything else the trustee indicates will be needed. If you're not sure if the item is appropriate, consult with an attorney. The logistics of the creditors' meeting. Parking around a courthouse or a court facility can be notoriously tricky. It's a good idea to make plans for parking before the meeting, so you can arrive about 30 minutes early. There might be several trustees holding meetings simultaneously, and the extra time should allow you to find the right room. You'll want to look at the calendar posted outside the hearing room door. The trustee will set about 10 cases during the same hour, so you'll want to see where you fall in the order. A judge won't be present. The trustee will conduct the hearing. Creditors might attend as well, although in many bankruptcy cases, creditors don't show up. The trustee will swear you in, and ask a series of questions under oath. If satisfied, the trustee will conclude the hearing. Otherwise, the trustee will continue it until another day. A continuance is rare if you've produced all required documents on time. The length of the 341 hearing. You'll be one of about 10 debtors set for the scheduled hour. Once the bankruptcy trustee calls your case, things move quickly. The bankruptcy trustee will ask a series of routine questions and inquire about any issues or matters needing more explanation. A creditor's questions can be short, as well. If they aren't, the trustee will usually continue the debtor's meeting for another time to allow further questioning. In most cases, the hearing ends after 10 minutes or less. Typical questions to expect at the meeting of creditors. The trustee will ask a series of routine questions that must be asked of every debtor. The trustee will then ask about any particular problems that arise in your case. Most bankruptcy attorneys can predict what the trustee will ask and explain the situation ahead of time, to both you and the trustee. Typical questions include: did you review your bankruptcy petition and schedules before you filed them with the court? Is all of the information contained in your bankruptcy papers true and correct to the best of your knowledge? Did you disclose all of your assets? Did you list all of your creditors? Have you filed for bankruptcy before? Has anything changed since filing your bankruptcy? Are you required to pay any domestic support obligations such as alimony or child support? Have you filed all tax returns as they have come due? Have you made any payments to creditors exceeding $600 in aggregate in the last year? Does anyone owe you money for any reason? One of the benefits of falling toward the bottom of the calendar is knowing what the trustee will ask. What to expect if creditors appear at the 341 meeting. Although your creditors will get notice of the 341 hearing, most won't appear. Here are a few instances when a creditor might appear. The creditor wants to ask you about recent cash advances or credit card purchases. The creditor seeks information about disclosures that differ from that put on a credit application, such as the amount of your income, or a creditor is a hostile former business partner, spouse, or another individual concerned about not being paid. Most creditors use the meeting as a discovery tool. They'll ask questions about your dealings with them to determine whether it will be worthwhile to object to the discharge of the debt you owe. If the creditor has a legitimate issue, they'll likely be willing to settle the matter without litigation. If the matter appears serious, the trustee might continue the meeting to allow the creditor additional questioning time. The trustee will be especially inclined to do this if the questioning could reveal hidden assets, because the more money the trustee distributes, the more the trustee gets paid. Thanks for watching. Please leave a comment if you want to see more videos like this.